act on that enforcement. And as I said in my email, once we discuss that, there's another element that I'd like to bring up in regard to this.
Okay, thank you. Paula, you have any clarification on this?
I don't. I think at the time, you know, as we were all aware with all the information that I provided from MMA, the sign billboard law statute is quite comprehensive and fairly ambiguous. So I think at the time, there was not a clear answer here at the meeting on whether or not members of the public could remove signs off the public right-of-way, although we do know that that does happen. And, you know, we find them, you know, and so long story short, this board decided not to try to regulate signs, and I think that was the original idea, was to regulate what types of signs could be in the public right-of-way, and that hinged upon First Amendment protections and all of that. Since then, I also reached out to the town's attorney on behalf of the Hampden Historical Society to make sure that their placement of the 4th of July signs were in keeping with statute. And it was referred to Brent Singer, who is one of the partners there, who has dealt extensively with signs and sign law. And so he answered my questions relative to those signs, but I don't know exactly what Councilor Jacobus's questions are, so I don't know that I have an answer.
I can elaborate on that. So I guess, first of all, again, you know, I would like to either suggest or maybe through other mechanisms, make sure that the town is actively enforcing the law, the main sign laws, which say that the signs can only be up for 6 weeks at a time during each half-year period. So each 6-month period, and that the signs need to be signed. Whatever organization or person put them up has to have their name on them. And let's see, there was one other thing too that's oh yeah, there's things about how close they can be put together and so forth, because without that, I'm afraid that, you know, we could be, and we're already seeing evidence of this, having numerous signs all over town, and people whose property abuts those signs really don't have any options. A $250 fine if you move that sign or you deface that sign. I guess the other aspect of this, which bothers me, and it kind of gets into this discussion of what, you know, a right-of-way is. You know, it's my understanding, I know this isn't universal throughout Maine, but in general, the person who owns the land would own the land up to the center of a roadway, and then the town or the state has a right-of-way to do highway work, road maintenance, utility work, clearing, and so forth, over a section of that land from the center to some designated area, certain amount of feet off of that. The public, in those circumstances, they have a right of passage over that land, but that's kind of where the general public's rights usually end. Like for example, if somebody was to take a snowplow and scrape up your landscaping on the public right-of-way of your abutting property, that's not supposed to be allowed. And there's other examples of that. So when it comes to the main sign law, I think it's interesting that even though the purpose of these right-of-ways are really to provide maintenance and access for the town or utilities, that all of a sudden the landowner is giving up its right to decide what signs are on that. I think it's almost like a matter of property rights to me. I know, for instance, if it was political signs that were going up and somebody put a bunch of political signs in front of my house that were in direct opposition to my political views, I would not be happy about it, and I would like to do something about it. And so I know that at the municipal level, we really can't do anything to change the state law, but I would hope that we could maybe talk to our representatives and see, if they would be willing to challenge this idea that people have no say about the signs that are being put in front of their house.
Dennis?
I have a question and a comment.
Yeah.
So is it your understanding, and I don't know the answer to this question, that while you or I as a homeowner could, I thought, deny the placement of a political sign in our front lawn, yes, we can. It can only go in private property with the permission of the landowner. Okay, again, I'm not certain of everything
Yeah.
here. If that's the case, that it's different for commercial signs, that Jack's Stump Grinding could put a sign in your lawn, and
I wish it was that way, but if you remember on Paula's discussion about First Amendment rights in that Supreme Court case that came about because of that, in general, there's not supposed to be a real distinction between the message that's being put on the sign. And what I've seen in the research is that a landowner does not have the right to remove a political sign. That's what concerns me.
so all of the work we've done campaigning has been voluntary on the part of candidates? I'm going to see if Jack Smith will allow me to put a sign in his yard?
Well, that's past the right of way, okay?
Not necessarily.
I know. That's what worries me about this, because
Okay.
my reading and understanding of the state law says that we can't do that. And I can just imagine what would happen if somebody got the idea, to put opposing political signs on somebody else's property that was,
I'm not the lawyer and I don't know, but I doubt that that's current case law.
okay, that's what I was researching, that's what it said it was. So if we could clarify that, that would be great.
Okay. So we do need another opinion, unless we have it in front of us, clarifying that point. The other thing I'm going to say is, if it came down to a contest of laws, I think the First Amendment's going to trump anything about right-of-ways or anything else. And as far as the actual practical part of this, in order to not run afoul and create a potential liability issue for the town, we would have to create a database of every single work sign in Hampden, of when it was placed there and by whom, and is it in compliance or not? Because without the date, you can't go around and say, well, this is time to be removed.
Right. So again, just to clarify, the date is supposed to be placed on the sign when it was put up. So I'll just give an example. I'm not saying this is the way the town should do it, but this is the way, it could do it. If Public Works were to go out once a month, and one morning probably, look at the signs and see the date on the sign and whether it was signed, and depending on the date that it was put up, it would either be in or out of the period, and it could be removed, and you wouldn't need a database.
You're relying on the accuracy and honesty of the sign placer. I might get wind of this, and I'm going to change the date on the sign. I'm going to put it up on the 10th, saying it's not up till the 18th. And who the hell's going to know that? I mean, I don't think you want, and I don't want our town staff involved in that kind of policing, which I think would become pretty burdensome. I don't think it would be just an occasional sweep. Not sure, but that would.
Yeah.
Paula?
So if any town department was to check on signs, it wouldn't be the Public Works Department, it would be the code enforcement officer, and he does have that authority under certain parts of ordinances and certain parts of the law.
Right.
He periodically does, if he sees a sign that he thinks is not, he checked on one just the other day that was in the public access, the controlled access highway on 202, and removed it. But he also, if he goes out and finds that there are no names or numbers, no contact information on that sign, now he has to try to track down who owns that sign by whatever it says on the sign, because they have a right to rectify it. They have a right, because some people don't know what the law is, and they don't look up the law before they place a sign. And so then they're given that opportunity, but he has to also, in 30 days, go back out and check to find out whether or not it's still correct. I had this conversation with him today. I know you're looking at me skeptically, but
Yeah, I think he's being nice. I mean, if it's,
but that is the process that he employs, and typically it's usually when there's a complaint, or if he sees something that doesn't look quite right to him, he might check it out. But it would be a cumbersome task for the code enforcement officer to be constantly policing signs when there's other things that take more precedent for him in his daily work than that.
yeah, I guess my question then is, you know, I realize that this is, you know, an additional burden, but as we discussed in previous meetings, there's been kind of a proliferation of these signs, you know, around town. And again, what's the method of redress then for Hamden residents if we can't remove these signs ourselves, and there's not anyone that's enforcing the existing regulations? I mean, with, you know, is it going to be if residents complain that the signs are looked at? I'm just looking for some way that you know, we can help Hamden residents with this issue.
What I would suggest as a possible avenue to move forward, you've come up in our email to council with at least 3 specific questions, and now that we have a contact who works on this through our legal attorneys, can you actually address those questions directly to Paula so that she can reach out to the attorney
Sure.
to get a response to it? That's number one.
Right.
Number two, depending on what you hear, I don't know how we can actually move forward without some proposed language that we could act on at a council meeting relative to an actionable item. And depending on what language you get back, what answers you get back, it is certainly within your right to propose a motion that we would consider at a council meeting relative to addressing some of the issues, and let the chips fall where they may. I mean, council may say yes, they approve it, particularly after public comment. We may in fact say we don't approve that, but I think the ultimate challenge, as Dent was referred to at Dennis, is I'm not so sure it'll stand the legal. I mean, we could pass an ordinance that won't stand a legal challenge, but that's a solution in and of itself too, and that would certainly help you in understanding that the language we're coming up with or the remediation we're suggesting is just not going to stand up to legal challenge. But we're in a quandary right now of how to move forward. You've got some questions that need to be answered, and then we have to have an actionable item.
Right, right.
Are you willing to?
Yes, yes,
okay.
and in particular, the political sign one, I think, is a real important one, because that bothers me that somebody could do that.
And I will remind the public that really what initiated this was the preponderance of signs by businesses that don't exist in Hamden
Right.
and therefore are not paying any taxes in Hamden. And there was a question as well, why is that fair to the businesses that are in Hamden when they can advertise? So anyway, there's a lot of things that have there, but what I would ask is if you're willing to get specific questions to Paula so she can reach out to legal counsel, get that back to you. And then after that review, if you still feel strongly, I would suggest that you in fact propose a new business item that we can act on one way or the other.
Very good.
Okay? Anything else from council? Okay, thank you. Next item under unfinished business is proposed amendments to the council rules of procedure requested by Dennis. Yeah, I'll open it for public comment. Council rules of procedure are the articles that council has that actually governs how we handle business, how we handle our meetings, how we select our leadership. There's just, I think, 5 articles altogether. The last time this was reviewed or amended was 2025. There was some minor amendments, but it does look like it's time for probably a thorough review of council rules of procedure. And so that's what council is going to be facing looking forward. And I guess what we would like to hear first, is there anybody in the public who would like to comment on council rules of procedure moving forward? Terry, if you want to come up to the... Press the button there. Thank you.
Well, I appreciate that you're asking for public comment, but at least from my perspective, I have no idea what you're proposing. Can I just look at 12 pages of stuff and enumerate every single one of those? Because I have no idea what you're proposing, so it's difficult to comment.
Okay, that's a valid issue. Yes?
All I would say is I agree with the comment. This was merely an opportunity and workshop to see if someone came in with a specific idea or concern. There'll be definitely a phase where we're looking at a product that everyone can look at.
Okay.
There's no question.
Thank you.
What I was hoping to do tonight is actually, as Dennis alluded to, the difference in the workshop is we don't act in business on the workshop. This is actually where we get ideas from the public. We discuss ideas here. We hear from staff. We hear from our department heads. And then out of that, we derive the new business items that we will review as a council meeting. And this process was actually begun in March, and it was kind of suspended because of our budget process. And so tonight, my intent is probably to lay out a timeline as to how we might proceed to do this, with getting maybe some ideas from the public, some ideas from council tonight, and then have a working document that we can post for the public and act on, or not act on, discuss at our next workshop. What the topics that might be of interest and the rule changes that we might want to be considering. So with that, with no other public comment, I'll open it up to council. Dennis?
Couple comments introducing this. One of the reasons we delayed the work was frankly because Councilor Jarvie wasn't here. And I don't think it's any big surprise to a bunch of people, but if anyone knows Robert's Rules of Orders, it's him, not us. And secondly, this council, like a lot of councils all around the country, hiccups. And the bigger ones always have a lawyer in the room, and someone will amend a motion, and someone will vote, and they'll say, wait a minute, was I voting on the amendment or the motion? And someone has to clarify that. So that's what we wrestled with, trying to be clear about ideas, to listen to people, and have a procedure that works at the same time, that's functional. And I find it a struggle sometimes. So I know that Councilor Jarvie has already started redlining the existing ordinance or rules. I don't even know what it is. I had some specific ideas, and if it's okay with you, I would just start mentioning a few.
Sure, absolutely.
This may not go in the order of the existing document. The first one I have is simply exactly to clarify how we create agendas. The current language says who can submit an item, or whatever. And I'm not saying it's not working, but it doesn't specify, should the chair be contacted by a current counselor, and then the chair relays that to the town man? How does that work? We don't spell that out, and I think we need to get a little more clear on that. I'm still hung up on the difference of abstaining versus recusal versus present. And personally, I haven't heard a good distinction of those. It's been a thorny issue in the past that I thought was clarified in terms it was definitely appropriate to abstain from a vote. Maybe that's what present means. But I think it might be helpful for all 7 of us to have a refresher on that. Not tonight, necessarily. I think we should revisit expectations and procedures on public comment to both ensure that the public feels, in general, they have fair access without letting anyone, public or council, dominate a discussion too long. We've addressed it in little ways. It seems to come up and down. It comes and goes. But there are some times when people in the audience feel differently about a subject, and someone thinks, well, so-and-so got too much time to talk. I just think we need to be clear on that and then broadcast that. Now I can't read my own writing. Section 3.1, item G, new business. I had a question of, I know what it is. It's about when can you vote on new business. And I wasn't sure how that should connect with workshop discussions or not. I don't see it as a requirement because I think the town manager will more than occasionally run into situations where elements in time around are saying, we need to do something now, and she doesn't have the time for a council workshop and then to a council meeting and then to a vote. But I think we should clarify that. Did that one. Section 5.3, I wrote myself just a reminder. I don't know what that means. I apologize. Section 6.3, 6.4, and 6.5 talk about specific statements from counselors, and I have a question about moving the question. If someone says, I move the question, does that require a second? Is it, those kinds of things again? And if we've covered it before, I apologize. And that's all I had to start this off tonight from me.
Any comments? I would concur with your concern. We have to clarify the public comment section. We really don't have any good guidance in our rules of procedure on how we handle public comments, and I think we deserve in creating a transparent atmosphere with the public and the fact that we want to make sure they're heard. I think it related to that, and this is allowed, quite frankly, under Robert's Rules of Procedure, if there's expertise in the audience during our discussion that, in fact, we should be hearing from, can a counselor, in fact, yield the floor to a member of the public to clarify those issues? And right now, that's not something that we can do, and I think that's really hurt us in the past where we've had expertise out there that could, in fact, help clarify the situation. So I think that is a big issue. Dennis, your idea about new business relates back to no business will be acted on in its first reading. And it's interesting that got in there because I don't think it was ever intended to usurp the possibility on acting on time-sensitive items. My interpretation of first reading, however, is that quite frankly, if it's been held in a workshop discussion, we've already had, that essentially is analogous to the first reading, so we can act on it at a subsequent council meeting, even if that's the first time we've seen the motion. What I think the original intent of this is for a council, because remember, council members can introduce new agenda items at the start of the council meeting. And I think what that language was intended to do is prevent a council member to come in and present a new business item that says, we want to dissolve the town of Hamden. I mean, I'm being extreme there, but you get the idea that that's the first time anybody's been exposed to us. And I think what they're trying to do is make sure that councilors have the opportunity to think about this, certainly get in touch with their constituents and understand how they need to debate the issue. And so that issue clearly has to be clarified as well. But there is going to be time-sensitive information on or time-sensitive action that does require essentially something from the town manager that says we do need to do this on short notice, and that has to be in there, so it's clear that will be an exception that probably does need to be in that language. And I see where you're going with section 6364. I get that, and we'll clarify the abstentions and presence and those kinds of things for you as well.
Yeah, question. On this discussion of when we can discuss new business, would one possibility be if there was an agreement among council that was present when the new item came up, that we all agreed that this is something that we had a good enough understanding on to vote? There
is, in other sections in rules of procedure, by a unanimous vote of council to proceed. And that might be one way to handle that, yeah, this is an exception, but by a unanimous agreement of council, we're willing to consider this because we think we are in a position to consider it. I do think another thing that has to be very clear in rules of procedure is the opportunity or to remind council members that they always have the opportunity to table further discussion till the next council meeting. And sometimes I don't think we utilize that tool enough to delay discussions when it is when and where it's appropriate. So there are going to be those kinds of things, Wally, that I think we can include in there. So with that in mind, I think what I will do is take these comments along with what I had previously circulated. I'll prepare what I will call, for lack of a better term, a draft revision to the rules of procedure. And Paul, I would ask that be published as part of our next workshop, that document, so that the public will have the opportunity, certainly, to. Terry, I'll yield the floor for you if you got a comment. Yes, I do. As a former council member.
Your reference to the first reading, acting on a first reading, and you said that you consider discussion in this circumstance as a first reading. I disagree with that. This is not the town council. It's town councilors here, but it is not the town council. The town council sits twice a month, first and third Mondays of each month. That's the only time there's a town council. There's a collection of councilors sitting around talking about stuff, but you are not the town council as you're sitting here.
And I respect that, and I think I'll seek legal, because I think I see where you're going with that, and that may in fact be a valid point. It was my interpretation of first reading why it was in there.
Right.
To keep from acting on something for the first time that they heard it.
Yeah, no.
And to which I said, well, if we're discussing something in workshop, we will have information that will enable us to enact when it actually comes before council as a new business item. So, valid point, and we'll seek guidance on that.
But let me throw in a curveball on this. I can definitely see people staking a legitimate claim to a problem if a collection of councilors that was not the council met here on the second Monday and had a discussion without giving notice or without being inclusive to the public, which might convey to some people that it is a functional council. I mean, I don't know how to describe it. I'm not going to say council meeting because it's not, but I'm not so sure it's black and white.
Well, my response to that would be, is there any circumstance you can think of? Could you take a vote right now? There you go. So
Well,
you are not
The
a
only
council.
vote permitted at this time is to go into executive section. That's the
Correct.
only actionable item in a workshop.
Absolutely.
Yeah.
Yeah. So again, you're not the town council while you're sitting here in a committee meeting, or workshop, I guess is what you call them now. Like I said, the only time there's a town council is on the first and third Monday. So, at least that's my position anyway.
We'll seek input on that. Thank you.
Thanks.
Anything else from counselors? Okay, thank you. First item of new business tonight, council discussion regarding data centers and possible moratorium requested by Councilor Marble. Do we have any public comment on this item first? Is there something going on up there that I? No, that's just continuing. Okay. Dennis, you want to go ahead and introduce this?
Like I think all of us, been catching bits and pieces in the news and whatnot about various proposals from various companies to bring new economic activity to a town, and the pushback on a lot of towns is concerns about infrastructure and electricity costs and usage of water and all those things. I know that at least 5 municipalities in the state have enacted moratoriums since 6 weeks ago. And as you'll all recall, the state legislature passed a bill that didn't go into effect only because Governor Mills vetoed it. And I believe that was the one that would have accepted a smaller proposal in the town of Jay utilizing the existing infrastructure from that mill. So I didn't want to come to a workshop preloaded. I didn't come here saying, here's all the research, this is what I think we should do. I came to do 2 things: to find out if there's any interest on the part of council and the public in looking into the possibility of clarifying the town's position on this. And if so, would there be agreement to direct initial work on that to the arguably overburdened town staff again, in terms of coming back with a draft proposal or key points for council consideration in another workshop? I'll close by saying I'm not aware that there's any existing proposal. I'm not aware that there's any reason this has to be on Screech. But I think it's a big enough topic that personally I think we should look into it.
A little bit of groundwork about moratoriums, and Paula, I'm going to look to you because I recall at one point we had a moratorium relative to new marijuana facilities. And as I recall, the challenge with moratoriums is they can only be for a fixed time and they have to be renewed. Not that that's a bad thing, but that would be the groundwork for any moratorium that we might come up with. So, Paula, you have anything you want to add to this?
No, I think simultaneously we probably would be working on the zoning ordinance, because that would be where the regulations for the data centers would be. And if we were not able to finish working on the zoning ordinance and we got an application for a data center, then I think we would immediately try to institute a moratorium.
And that would not be too late? The timing of that would be defensible?
Well, it would depend. I mean, it was very, very close for us with regard to the marijuana piece. I would have to double check with legal. I mean, I think because they're only allowed for certain length of time, and I think you're only allowed 1 or 2 extensions. We were at the max with the marijuana piece. I wouldn't want to do it too soon, but at the,
And I agree. My only concern would be appropriate work has been started. There's everything else going on. And in the middle of that, a proposal lands on your desk
Right.
from a business, and we have not discussed and passed a moratorium. So my question is, would it then be too late or illegal to start a moratorium at that point? Because it feels like it would be.
Yeah, you're probably correct that we would have to have the moratorium in place already. And I don't know what the planning board's schedule or thoughts are as far as any discussions they may have had at this point in time about regulating the data centers. But I think if we're going to start looking at that, we probably should start the moratorium immediately so that it's concurrent.
Mr. Chairman?
Oi?
So I had a constituent contact me about this, independent from you, and they wanted some discussion on that. And I guess my first response to the constituent was pretty much what you were saying, Paula, that I thought we probably already had other things in place through the planning board and zoning and so forth, where they would have, where if a data center was coming in, that they would have to have some type of approval. They just couldn't come in and just put it anywhere. I guess personally, a moratorium, I almost like to know a little bit more about, where the proposed site was going to be, what the data center was, how big is it going to be? Is it a small one? Is it a large one? Are they going to have their own power source? I'm a little bit hesitant about a blanket moratorium without having some idea of what we're trying to prohibit. If you look at data centers and across the nation, there was a lot of states that are actually courting them to have them come in. And recently there's been a lot of pushback for very good reason, against them. But again, I think using the J example, it can be pretty much site and size dependent. I'm not sure that all data centers are bad. But I would hope we'd have mechanisms in place in town where we could sit back and review a proposal, and if we didn't like it, we could deny it without putting up a blanket moratorium.
Council does have the opportunity to ask the planning board to look into something, and this might be something that we would ask the planning board at this point to take a look at this and come back with a recommendation to council. How does that sound? Again, the problem with the moratorium, and I understand where you're going, but if we're proactive and start a moratorium right now and we only have a fixed timeline that it can be enacted and a fixed number of renewals, and that application comes in after that, then we're back at square one. So we kind of caught between a rock and a hard place. So I would suggest that we ask the planning board to visit this and come back with a recommendation. I do agree that at this point, knowing that what I know about our zoning ordinances, I suspect it's going to be pretty difficult for any data center to come in without having to go before the planning board in a very extensive review, but that's
Right.
just my opinion.
That's
So,
what I thought.
okay, with that, we'll ask planning board to review this then, okay? Next item is council discussion regarding Discover Church open space sale, requested by Amy Ryder, Director of Planning and Development. Amy, if you want to come up and talk to us about it, please.
I believe Kanishko might have something to put up for the benefit of the public on the screen, the map. I don't know if he heard me or not. Is he in there?
Looks like it's coming up now. Yeah.
So I'll go ahead and start. The leadership team of Discover Church approached me, a while ago now, in effort to try to solve their problem of parking. It's a good and bad problem. They have a lot of attendance, but their parking is maxed out. And I've also heard from residents on Horseshoe Lane and concern of the amount of people parking on the street, blocking driveways and whatnot. So when I spoke with them initially, unfortunately, their lot didn't have enough room to expand their impervious surface based on the zone that they're in. So I have to give them credit. They went above and beyond to buy a lot 2 down in hopes to combine with this open space from Westbrook Terrace so that their larger lot is now plenty big to expand their parking for their patrons. When speaking to them, or doing research about Westbrook Terraces, happened in 1987, and I cannot find any documentation of mandated open space. So when I reviewed it with town staff, which was Victor, the engineer, and Miles and Code mainly, and John from Public Works, they really wanted to make sure that we had an easement for any stormwater drain and that it maintains the same character and does not interfere with the stormwater drainage. All of which they're in compliance with and happy to do, and even put deed restrictions in that it maintains as open space minus the small, oh, he doesn't have it up there yet.
Do we have an overhead? He doesn't have it.
I can pass this around. Oh, okay. Just gonna put it up for
We
them.
want to pass that around to the public so they can look at it.
Thank you, sorry. So, needless to say, I think that they are more than willing to work with us and do what's best for both parties. I do think it would be beneficial for town residents as well, especially those who live in the area. And
Amy, you do have the council packet now indicating a lot over your shoulder.
thank you. So, as you can see, they bought the parcel 2 down, and their goal is to make that parking with a walkway that would walk through the town parcel and get to the church. So just an extension of parking. They're not disturbing the stormwater feature, or doing much invasive work at all, to say the least.
Amy, could you point out where the open space
Yes,
was
we
or
have that.
is?
If you look at the next slide, Amy, I think it's more clear.
Go.
Can we scroll down to the next slide? There we go.
This parcel here is the town parcel. And we've even discussed putting in the deed that they would maintain this buffer so that this would never even be disturbed, and that they could only put the walkway in here. And then again, the town would maintain an easement to access any stormwater features, and they would not disturb the stormwater features.
Right, so the real thing, is the real question then, is it okay to put this access walkway through the open space?
Yeah, Wally, before we start discussion, we want to make sure we get some public comment.
Sure,
too.
okay, I'm just trying to understand the
We also have members of the church here
Right,
if you're
so-
interested in.
So when you're done, I'll invite the public.
Sure. I mean, I'm essentially done. That's just the overview. Again, I think it could be a win-win for everybody.
Okay?
Yep.
Members of the public then want to come up? If you want to come up to the dais and speak? Any comments? Yeah. And again, just remember that if the green light's on, and introduce yourself and where you live for the public that's tuning in remotely.
Yeah, Albie Valcourt, 205 Monroe Road. As far as the open spaces, who owns the open space? That's a question to you guys. Does the town own it? This is a workshop, right? Does the town own the? And those are, when a development is set out, that part is already negotiated between the developer and the town, and it's an open space. So in other words, now if you're gonna sell these open spaces, does that mean every single open space within the town of Hamden is gonna be open to sale? There's open spaces all up on Western Avenue. There's open spaces all up and down every development that we've had over the years. So what do you, I know this is one thing, it may be a good thing to get for the access, but what kind of can of worms are you gonna open up on every one of these open spaces? There's open spaces here that I know we had an issue with hunting off Western Avenue. We found out that the state said, no, they had to shut it, they had to keep it open. So these different open spaces, there's some all over the place. And they are town-owned, and the town should not maintain it, but keep their possession of it. And for the future of and what was the determination of the open spaces? Why did they have open spaces for all the developers? Now, shouldn't some of these developers, some of the funding go back to them because it was their property? Those are just my questions, and just, yeah,
Thank you for your input.
things we're gonna open up a can of worms.
Thank
So,
you.
Thank you.
Any other members of the public?
Son, Ron Hardy, 85 Summer Street. Just a point of clarification, because I heard it mentioned here again. So the proposal is to build a walkway across there. Does that include a road? What's the principal way
Can
into?
can we scroll back to the first slide? There we go. Yep.
So, and I saw this in the council packet, although at a much reduced scale. It wasn't clear to me that that walkway wasn't the only way into that parcel. And so if it's actually a roadway that crosses there, as opposed to just a walkway to walk to the interconnected parking lot, my question is, does this design consider a culvert that's sufficient to pass water there? I don't know. When I read this and read that it was an open space and that there was stormwater drainage there from the neighborhood, and I understand why these open spaces were created and the function they provide, it wasn't clear to me that the drainage would be maintained across there, especially if there was a significant barrier such as an elevated roadway. And so my questions would be, if this goes through, are we going to have a design that shows what the impact is to water movement on this parcel? So,
Thank you.
My name is Alexandra Truorgy, and I am on the leadership team for Discover. So if you go to the slide number 20, if they can hear me. So the open space was created from my research, and it took a while to figure this out, but this open space was specifically designed for the stormwater system that operates for the subdivision. And so what we're proposing is to actually put in the deed restrictions that we will not touch the stormwater system. You guys will have an easement over to fix it, and that we will leave that strip free. What we're looking for tonight is really just a head nod if this is something you're willing to consider. Because what we have to do after this is go to the planning board and do a minor subdivision change, which will require a public hearing. So the public will have time to ask questions. Then once the planning board, assuming they approve it, will come back to you to make sure that you guys agree with the deed description, all of that. Assuming all of that happens, then we have to go back to the planning board with a site plan that will show the parking lot on lot number 3 and the walkway. At this point, we can't actually say whether it would be like a physical walking path or if it's a one-way, like a car can drive one way on it. Where it's too far out for us to spend that kind of money. We did have it surveyed, and we looked at wetlands and did all that kind of stuff. So it will take quite a bit of approval and quite a few public hearings for us to be able to answer those kind of questions. The parking is very intense on Sundays and anytime there's an event. I know the church tried to move to 3 services on Sunday to kind of help the traffic issue. And I mean, to our surprise, it helped a little bit, but not really. We just ended up having more attendees come. So I'm hoping that we can come to some sort of compromise to create another parking space for the parishioners. So yeah, I know you can't make decisions, but can you
Well,
guys
the
discuss and head nod us?
council can, through the tenure of our discussion, I think you can get some idea about how we're going to, but I will I will ask this of you as you move forward. This kind of thing, it's going to be very, very important that you seek input from the abutting property owners, and it's clear you are expecting to do that, but at every step of the way, because there's going to be significant abutting property owners, and that's a requirement in these kinds of reviews
There
anyway.
should be a letter from one abutter. There was going to be a couple others that came tonight, but they were unable to. I live in the neighborhood down the road a little bit. But yeah, it's a requirement for, I think, the subdivision amendment and the site plan and planning board approval. So we will absolutely do that.
And I would also suggest that the issue of a non-adjacent, non-permeable surface is going to have to essentially be addressed, because essentially you're increasing your non-permeable surface for your entity by moving it to another spot. And we want to make sure that
Yeah, so our goal
you
is
addressed all that.
right, is to actually combine, so we purchased that lot there, we have the church, is to combine this as one single lot. You can kind of see it in blue. And then we will still have to watch it, like you're saying, you know, maybe tear down a house or garage on that one lot to make sure that our numbers match. But as 3 independent lots, or even if we had these 2, it doesn't help us. And that's essentially why we need that open space, to keep it open, but to increase our impervious allowance.
Could,
Paula, you had something first?
I just wanted to remind council that there has been other opportunities in which you have sold open space and for the public's benefit, and it was based upon specific needs. The town still has quite a bit of open space out there, but there was a situation where a cul-de-sac needed to be widened. There was another situation where property needed frontage, a certain amount of more frontage. So there have been certain situations where the town council has sold open space for a particular benefit. So if that would help.
yeah.
Wally?
Yeah, I'm still trying to understand what's going on. So, right on the diagram that we have, this one, not that one, it looks like this is supposed to be a 24-foot wide, I'm going to call it road,
Okay.
okay? If that's not a road, how do people drive in, given this current map? Do you have other access to this other parking lot?
Well, so like I said, we've done our research on it, and that map shows a general idea of what we're looking for. But for us to spend money to do the site plan, you know, get in league with Miles, and to decide exactly what we can do, we need to do the subdivision amendment and get that middle lot from you guys. So I can't actually guarantee you how wide it would be.
Well, how else are cars going to get in it? That's my
Well, okay, I
question.
see what you're saying. So you see on Daisy Lane, there's an entrance there. There's also entrances over on Main Street on that 3rd lot. And you guys have pretty strict regulations on traffic flow, ins and out, access points. So that's what we currently have. We have 2 entrances on Main Road. We have 1 entrance on Daisy Lane. So we would have to, you know, work within your standards and your code to
Right.
develop this properly.
So to get, again, just so I'm clear on this.
Yep.
So the smaller lot, which is connected with that, to the road, by that roadway there,
This one?
yeah, the very first one,
So they purchased this lot,
Right.
Molly? Just
Right.
So you know, so they can now access it from Main Road.
good, that's what I wanted to know. Okay, all
Yes.
right, all right, thank you.
Dennis?
I want to be the dumb guy up here with 2 questions.
Okay.
The first dumb question is the current open space lot being considered to be developed as a parking lot? Or does it continue to serve as mitigation?
I think that's important. So if everything goes well and we can do this parking lot will be completely on lot 3, which is, we purchased it, we own it.
Yep.
The only development that may happen on the open space
Is that
the
walk,
connector.
that connector?
Right,
Okay.
And there, besides your codes and your standards, like we've done a wetland delineation, so we kind of have to work around that. And like I said, there would be very strict deed restrictions that would stay away from the stormwater system. Like I said, I live in this neighborhood, so I don't want that stormwater system not to function properly. And we'd have a buffer in the back. So technically speaking, it would function exactly as it is, minus some way of connecting the two parking lots.
My second question is not for you, but hopefully for smarter people on staff. I have a rudimentary understanding of the roles of council and planning board, and I'm a little confused as to why this discussion is coming to council tonight first. I'm sure there's an answer.
As Ally stated, the planning board is a process, and it costs a lot of money to get an engineer and to do the amendment process and the site plan and whatnot. So I talked to Paula, and we thought it would be a good idea to run it by you guys to see if it's something you would even entertain before they went ahead and spent money that.
But doesn't the planning board have basically final say on?
Well, the council, the town owns this piece of land.
Okay, so this is about conveying a parcel owned by it's not about
No, this is
approving a
more,
plan.
they've gone above and
Okay,
beyond to show you a
gotcha.
concept to prove that they're not gonna develop it.
I gotcha.
Yeah.
And
Thank
they
you.
would need,
Is your mic on?
So, it's right here, it kind of goes like this, and it goes down like this. And then they purchased this lot, and they own this lot, so it's right in between.
So kind of in the middle. Okay.
And it's like a triangle, so the very tip of the lot kind of goes like this, and it goes up and over, and so they're using the very smaller part for the, would be using for the walkway.
Yeah, thanks, Amy.
Wally,
Yeah, are we open for council discussion now, or?
we do have one more couple more public comments then. Yeah, please.
Ron Haidu. I guess I have an honest philosophical question about not just this project, but anything else. I don't pretend to know the first thing about open space requirements, either now or past, but and this is kind of a ledger question, really. Was this open, I presume this open space was originally created when the subdivision was put in because it had to meet the then in ordinance or in the state law, a retained area based on other impervious areas, streets and houses and such. And so it met that need back then. If the town now sells this and another entity takes that same space and uses it to count against more impervious area that they're going to create on an adjacent lot by combining all three lots, are we somehow double counting the open space that was created or required or desired for both of these, for either of these projects, the original neighborhood project and now this parking lot project? And I don't know the answer to that question, but I can see where it might apply. As Al mentioned, if you open a can of worms here, or how are we going to count these or ledger them? So.
May I address
Wally?
this question? Yeah.
And I'm not an expert, so.
No. So I was on the town of Hamden's conservation board for 8 years, and we dealt with a lot of open space issues. And it's my understanding that the way that the town considers and the requirements for open space have really changed a lot over the years. For instance, on my subdivision on Ichabod Lane, which is kind of the time, was before the time that open space was required anytime a subdivision was created. It was really nebulous whether open space was ever put in. And it was supposed to be, but it was an oversight, and it never was. And so there was never a designated open space for our subdivisions. Many subdivisions, as Albie was referring to, had to have an open space. The developer had to set aside land, and the town planner and the conservation commission, and this went then to the planning board. We actually picked what sites were going to be used for open space, and it was our understanding that they would remain open space in perpetuity. Okay, so I share Albie's concern about these sites just being sold, but I know that town sentiment and attitude has changed since that time, and that other councils have felt the need or the desire to divest of some of this open space. So that's kind of my understanding of the history, however imperfect it might be.
Mary, did you have some comments?
Mary Kellogg, Ichabod Lane. It's a question about, I think you said that the access would be, there would be drive-in access off the main road directly into the newly purchased lot, and that would be the parking lot. Is that correct?
Well, yes, because he asked, but I really caution anybody from using that.
That's a preliminary plan.
This is a concept.
Okay. Here,
We just need a head nod before we can go through all the.
I understand. It's just a question. Is this this access between the two, is that to provide non-roadway vehicle access across that for people who park in the farther lot who want to get to the church? Is that to ferry people in vehicles that can't go onto the street and get them up? Because if they park down there, they could walk out. There is a sidewalk there. So why not just access that via the road and the sidewalk and not need that connecting link? That's my question. Thank you.
Terry, then we'll go into council discussion.
I didn't hear an answer as to how the town acquired title to this property. Was it through coercion? I mean, was the developer required to give up this land? And secondly, is there a distinction between open space and stormwater management space? My guess is that there is. That stormwater management areas are treated entirely differently than just a plain old green space. So, but to answer this lady's question here, partially, is that in order for, it sounds like to me, that in order to have the impervious surface available for these parking areas, it's necessary to have that third lot to purchase it, because they have to be contiguous in order to transfer from one property, from one lot to the other. It has to be a contiguous piece of property. So that's, but again, I don't know how, still haven't heard how the town acquired this. Was it donated? I doubt it. Was it purchased? No, I doubt that also. So, was it foreclosed on? No. So, that just leaves coercion. I mean, it was taken or forced to be given. Same thing. Right. So, it's not a matter of, to me, it's not a matter of, whether or not, the property is usable or anything like that. It's the fact that at some point in time, and I agree, open spaces, we were arguing about that a long time ago. But if and when the town does take something from a property owner, then the understanding should be that it's going to remain, in a non-taxable state forever. Otherwise, it would almost be like a racket. you know, where the town can say, well, in order for you to build over here, we're going to make you give us this. Then 10 years from now, say, oh, okay, well, we can make some coin on this. We can just sell these off, and you know, and the poor old developer sitting back saying, oh, gosh darn, you know, that didn't work out too well for me. But anyway, that, you know, so there's a whole bunch of questions here. I just think it's a can of worms that it should not be opened up.
Thank you. Amy?
I can answer some of the questions. So this was a stormwater easement, open space that was given to the town to maintain the stormwater easement. When I looked back in my research from 1987, I could not find any provisions that mandated open space back then, and nor was it on the Registry of Deeds subdivision plan. Typically, they have the you know, the contents and any restrictions or necessities on the deed, on the site plan itself, which I did not see. So that led me to believe it was just simply for the stormwater easement. In regards to tax, I mean, we're not going to be making tax dollars off this because they're a nonprofit, just so you know. But other than that, I think I answered your questions.
Council discussion. Wally?
Yeah. So, when I worked for the state, we dealt with issues like this quite a bit. And one type of resolution, the way it's actually, you know, I'm not sure if it's in state law or just state practice, but when land was taken, in this case, it would be for conservation. I'll give you an example that I worked on was the Portland Jetport. When they wanted to take wildlife habitat, they were required to provide a multiple, either pay or provide a multiple amount of land, let's say 3 times to 7 times the amount of land, depending on the species that was involved, to make up for the land that was being lost. And so, you know, I would think, you know, the whole idea of drainage, if this was only for drainage and rather than open space, I'm not sure how you're going to provide more drainage, but you know, I would certainly be open to the idea if there was some other desirable open space that could be provided, that might compensate the town for something like this too. So,
Other counselor?
I make
Input?
one comment
Oh,
that I
I'm
haven't
sorry.
included. So on the site plan, which I apologize I didn't bring, or the subdivision plan, there is a large parcel at the end of Charles Street, maybe? I don't, what's the one next to the Discover on the... Yeah, either, there is a large parcel that abuts 202 for the intent of open space. There was no verbiage that that's what it was, but there was a large parcel that said open space. There was no drainage easements, anything of that nature. So it was just the 2 on the subdivision, which led us to believe that this one was for drainage, and the other one was for recreation, was our assumption. Just to make you aware.
Paula?
No, I just wanted to follow up on that. There's been several iterations of the ordinances over the years when we've had conservation, recreation easements in several of these subdivisions, and there's been situations where the intent was to create an open space for recreation for the residents that are in the subdivision. Then that sort of became an issue about, well, whose responsibility is it to put in a playground or to maintain that open space? And then it became, there was a period of time when the developers were actually paying in lieu of setting aside open space. So to your point, I think we've gone through all of those various types of changes, but at that point in time in 1987, there was nothing captured in that subdivision plan.
right.
Wally?
Just an additional comment on that. You know, if this is truly only an open space that was supposed to be maintained for drainage, for stormwater drainage, and it's not, and the proposed development is not impacting the stormwater drainage, then I guess I have less of a problem, you know, with allowing this. If this was an open space for recreation or for people to get away to do, just provide some green space, and that was being taken up, then that might be more of an issue for me.
We can still put those deed restrictions, and they're very well willing to keep it as green as possible, minus the one walkway that they need, as well as an easement.
I'm not sure any current council members seated here were, when we had to address this with the 1A rebuild. The state clearly looked at that as a drainage area because we had to go in and rectify that drainage area and open it back up with the 1A remodel. So clearly, the state looked at that as stormwater drainage and not as open space recreational area. What I have heard tonight is pretty clear to me that in fact the intent is to maintain that stormwater drainage area with appropriate modifications as may be necessary. I would remind council this is a conceptual drawing, it's not a detailed drawing. There's a ton of work that has to go into this. And lastly, I will point out to both the public and the council that open space decisions are not blanket decisions. Open space decisions and modification to those open space decisions in my time, my 3 terms on council, have always been handled on a case-by-case basis. So any decision we make relative to this, after we see everything the planning board has done and everything else, has no impact on all other open space that we may have in town. And again, remember the distinction between open space, between green space and this storm water. This is truly a unique subset of open space, to my way of thinking. So I would certainly support the idea that I think they can move ahead with more detailed planning through the planning board and the process that's necessary, and then bring back a final detailed decision for full council consideration. Are there any objections or any further comments?
No, I would concur with that.
Dennis? I think council, granted, there's not a full council here tonight, but we do have a majority, and I think we heard a concurrence with their going ahead and moving forward with more detailed plans.
Thank you.
So thank you, Amy. Thank you to those of you who spoke. Paula, before we move forward, because we've got a lot of going on, are there remaining agenda items, less the executive committee decision that we must act on tonight? I don't mind going ahead, but we've already pretty deep into this workshop session.
I think the next agenda item is another
Time sensitive?
time sensitive with Amy.
Okay.
We could postpone the solid waste flow control ordinance discussion until the next workshop.
Okay, with council concurrence, because we do have a pending executive session, we will introduce, we will discuss new business item C, but we will delay new business item D till our next workshop in 2 weeks. No dissent. Okay, thank you.
How time sensitive is the I gotta look on my agenda here.
The expansion at Cary Drive is time sensitive, as is the executive session.
Right, and the solid waste isn't?
Well, based on staff, they said it can wait 2 weeks.
Okay.
All right, with that, we'll have council discussion on expansion at 44 Cary Drive, again requested by Amy Ryder, Director of Planning and Development. Amy?
So we have another kind of an open space thing. However, this is unique in the fact that when the business park, it was built under zoning provisions, not subdivision, as a business park, from what I could tell, and other staff members that kind of helped me look into it. Essentially, the U.S. Blades building was purchased. This commercial property management company wants to move their business from Orono to this new building, but that would require an expansion. Realistically, I'm here today to see, again, if you would entertain them going. I have made it quite clear to them that this is take a lot of DEP time and money, because the open space in the business park is really mandated through the Department of Environmental Protection for the stormwater permit, for the SLOTA permit. So I, again, am just looking for a head nod for them to even see if this is feasible through the DEP. It's not really a planning board thing. It would be a planning board thing with the major site plan and an amendment, but that amendment hinges on the DEP approval. So I just, again, talked to Paula about it, and this gentleman has reached out in May, and I wanted to get through budget season, and he is on a bit of a time frame himself, trying to move this one business here. It would provide extra revenue, commercial growth, so I'm in favor of it, but I think the hurdle they are going to come across is DEP, mostly time than anything, and to make sure that they meet these SLOTA requirements.
Thank you. Public comment. Terry?
Being as I am a property owner in the business park, I bought the lot under set circumstances. Each and every lot that's out there is a specific size down to the foot. And the covenants say, or somewhere in there says, only 70% of your property is usable to you, which is, a different, subject. But within that 70%, you can use 30% of that for a building footprint. So my presumption is that the current building that is sitting there now, absolutely, fits the bill as far as under the 30%. So I'm presuming that the 7,000 square foot or whatever, size it is that they want to expand it exceeds the 30% that would be available for that particular lot. Hence, they need to acquire additional property to do that. And again, as a property owner out there, every single entity that's purchased land out there, a lot out there, has had to abide by that specific requirement. Excuse me. So I would find it very, very difficult to understand how any one particular business within the park could alter that set of circumstances in order to expand the building. Because if that is the case, then every single property owner out there, including myself, would also insist that I get a piece of green space to allow me to increase my building footprint. So I can again, I think it's within, it's in the covenant, correct? I mean, it's not an ordinance or anything like that, right? It's in, okay.
So it is in the ordinance, he's right, we're in 70% impervious per lot and 30% building coverage, which from my understanding was mandated and put in place by DEP. So per lot, they configured it when they get the stormwater permit and all of that. So I don't disagree with the sentiment. I think that's why I have let them know their biggest hurdle will be DEP. And again, I said it's more of a head nod if they want to go through those hurdles with them and see if it's even possible, because I think it's going to cost them a lot of money and a lot of time. But I wanted to see if we would entertain it.
So in essence, Terry's concerns you would agree with based on the DEP mandate, but really it's not our decision at this point relative to stopping it as much as to say, do we want to allow this particular entity to go ahead and deal with DEP
See if it's
to see if it's
possible.
even feasible?
Right.
What it sounds like is, in fact, it may not be, but that's DEP's decision, and then we have to think about it down the road. So, okay.
Right.
Other counselor comments then?
A question for you, Amy. So the proposed building expansion, there's not an additional land that's being bought. They're trying to put this on the same
No, they're
footprint.
Terry's correct. They're asking for a bit of an extension beyond their property, which is green space, open space in the subdivision. They're asking to purchase a small expansion so they can put this 7,000 square foot building and combine the lot to make a bigger lot so they meet those impervious and building max. They can stay under the maximum. So, but those maximums were put in place with the SLOTA permit from DEP. So that's kind of where I'm getting at is I didn't want to tell him no. I was very upfront with him to let him know that, you know, these are the steps you're going to have to take even if you get the head nod. And I can't guarantee you'll be able to do it.
Right, right. So, I don't really want to call Terry back up, but I'm just thinking, you know, that as you're alluding to, it would be very expensive probably for them to meet the stormwater drainage requirements. But I also know from past experience, there's lots of inventive ways to get to do that. Expensive, but you know, inventive ways to do that. And you know, if that was available to the other lot owners, I'm just wondering whether they would feel that they were put up by letting this one person proceed with that. And it would seem that if DEP said, yes, you could do X, Y, and Z to achieve your drainage, that those options would then be available to the other lot
Ideally,
owners. So they could do
But
that
Wally,
too.
that's not a council decision. At that point,
Right.
it's a DEP decision, is it
Right.
not?
And I think eventually they would run out of space in general.
If you have property out there as Terry
Yes.
does, and assuming this goes through, I think Terry has every right to say, how come I'm being treated differently? But that's a DEP decision. That's not our decision.
Right,
Agreed?
right.
Okay.
And as far as the covenants go, I have not reviewed them in regards to purchasing land, but I do know that it's a civil, we can't enforce the covenants. So it'd be great for you to bring it up to them too if it's in there. I haven't read specifically that it says you can't buy more land or extend your property, but if it's in there, then happy to make them aware of it. The covenants, I don't think there's a covenant that's, I could be wrong, but it's a civil, we don't enforce the covenants as the town. Are you saying that there's a covenant that does not allow that? And you can come up.
My understanding of the covenants is that each particular lot that's out there is set. I mean, that was set when the park was designed and went through the whole DEP process. Every square foot was accounted for, and everything, the whole park is designed around that set of circumstances. Now, I don't think a property owner like myself, I can't, according to the covenants, I cannot subdivide my lot, okay? I don't think that I don't recall ever seeing anything in there that says that the town can't actually sell green space to somebody else. However, I don't know how anybody could ever utilize that other than as a offset or as to gain other footage on there. But again, that, you know, that, to me, that creates an odd situation for every single property owner that's out there, you know, to do that. But I don't think one single property owner, me included, could apply to the DEP as an individual to alter the permit that is currently in place for the park itself. Not each individual lot, but the park itself would have to be, I would think, that DEP is going to say, okay, if you want this over here changed, we're gonna have to change everything. You're gonna have to we're gonna have to reconsider every single piece of property that's out here and rework this just to make, you know, to make it work. So I don't think one individual lot owner could do that. I don't think. Maybe, but I don't think so.
Thank you.
But it'll be interesting. That's why I'm here.
Thank you.
Thank you.
Any other, Dennis?
Just to say it out loud in a workshop, it feels to me, if anyone's looking for an indication, that it's not cart before the horse, but I'm not sure how deeply we should be into considering something that in my mind right now is, as you just stated, more of a DEP issue than a town issue. And I know that doesn't do anything for the owner, but, you know,
Essentially, I could tell him he could reach out to DEP and see if it's even plausible. To Terry's point, I don't know if it is. And I didn't want to take staff time to try to figure it out until I talked to you guys either, so.
and to Mr. McAvoy's points, I don't always agree, and Terry and I have had this discussion for a long time, especially like worst case scenario. So if person A does B, then everybody's going to want to do B. I don't agree with those thoughts, but I think it's very sound to look at the entire project and the interconnectedness of it in terms of regulations like DEP. And I'm guessing, if it needs to be applied, that's a very valid point.
Terry's not wrong. It would probably alter the park.
Okay, with 4 council members back present, is there any dissent with suggesting to Amy that the next step will be for this entity to work with DEP? Okay.
That's reasonable.
Okay, so we believe it's reasonable at this point for them to look to DEP for guidance on moving forward then.
Thank you.
I just wanted to get one comment in. It seems to me that if it was desirable to increase the usage of land in a set parcel, that would have come up before now for multiple people. This question would have been asked multiple times, and if there was a way to do it, it would have been done. So the fact that we're sitting here discussing it and it hasn't been done suggests to me that the roadblocks to doing this are significant or impossible to overcome.
I agree. I just am staying true to my word to him. So I will also show him the lots that are vacant and hopefully meet his needs as well. So
Yeah, there are other vacant lots out
there
there,
are,
clearly, yeah.
I've tried, so.
Okay.
Thank you.
Anything else for council? Okay.
Just one more comment. I'll make it short. Believe me, I will. I think by telling this owner out there, yeah, go ahead and move this along, go to DEP and, spend a bunch of money doing this, I would think that that this person is going to consider that as a tacit, approval that this land or this green space, this open space will be sold to this person. Otherwise, why would this person ever spend any money at all if he has to come back and argue whether or not you're going to sell the property or to them? And, Mr. Marble's correct. We disagree on a lot of different stuff here, but I don't see how in this it's a specific area. It's an enclosed area. It's all designed. It's all specific. So yes, I would disagree with him in the sense that if it happens over here, it can happen over here, and if not, you better have a really good reason why it's not going to happen someplace else. So I said I'd keep it short. Thank you.
Okay, with that and with council agreement that we're going to suspend new business item D till the next council meeting, we're now going to go into executive session. We would ask those present in the audience to excuse themselves. For those listening on the public, this is our last item on our agenda tonight to go into executive session. There'll be no other actionable items or discussion outside of executive session. So with that, I'm going to say good night, Hamden, and we'll go into our executive session. Right now, I need a motion from council pursuant to one MSRA, Section 4056C, Economic Development to go into executive session to include the town manager and the public works director. Do I have a motion?
So moved.
Do I have a second?
Second.
Roll call vote?
Approve.
We need to wait.
Yeah, we gotta wait on
While
the vote.
he's availing himself. Thanks, Amy.
No, we don't. We have a quorum for business. He doesn't have to. But I'll wait.
I thought you needed 4 for quorum.
We do. We have a quorum for business, but if he were to abstain right now, he's saying he didn't. So we'll wait for him to come back.
Yeah. Thank you. So, just filling the air with golf talk for a split second. I hadn't played Jado in well more than 20 years. It was an MSGA tournament. And I had forgotten how beautiful that course really is.
I think it's,
And how well maintained it is.
I think after Sugarloaf,
And how friggin' challenging it
it's
is.
the second best one relative to being a beautiful course itself.
Maybe, but it's a good one. May we take a vote now, sir?
We're going into executive session and we need
He
to.
wanted a
Oh.
ramrod
Sorry.
vote without you being here.
That's fine, yes, I'm sorry, yes, we're in that's why I shut the door. I thought we were there.
John,
Oh,
we don't need,
finally, yes.
we don't need, no mic.